The first offense that can be used to void a contract is the presence of a mistake. There are two types of mistakes: mutual mistakes and unilateral mistakes. A mutual mistake can be invoked when both parties were mistaken about a material fact that formed the basis of their contract. The mistake must pertain to a key fact. It must go to the heart of the contract, as some courts have said. In that case, either party may choose to avoid the contract. That is, if one or both parties raise the defense of mistake, the contract will be invalidated. However, mistakes solely pertaining to questions of judgment or value are not sufficient. For example, if you buy an old painting and overestimate its value, that's not a mistake in the legal sense. It's only an incorrect assessment of the object's value. Similarly, if you buy an old painting because you think that it will go up in value in the next few months, but that doesn't materialize, there would also be no mistake in the legal sense, but only an error in your judgment. The contract will still be enforceable in both examples. The second type of mistake is the unilateral mistake. Unilateral because only one of the parties is mistaken about an important fact of the contract. A unilateral mistake can be invoked in two scenarios. The first one is where a party makes a mistake and the other non-mistaken party knew or should have known that a mistake had been made. For example, let's assume that Joe, a car dealer, knows that Peter, a customer, can only drive cars with an automatic gear shift. Peter comes to Joe and says he wants to buy a new car for himself, and points to a car that has a manual gear shift. He is not aware that the car has a manual gear shift. If Joe still sells Peter the car, Peter could later avoid it based on his unilateral mistake. The second scenario for invoking unilateral mistake is where the effect of the mistake is such that enforcement of the contract would be unconscionable, that is, extremely unfair. An example of this second ground, unconscionability, is seen in the case of Donovan versus RRL Corporation. In Donovan versus RRL, a car dealer advertised a used car for sale in a local newspaper. However, due to a typographical and proofreading error by the newspaper, the ad contained a sale price that was well below what the car dealer had intended to advertise. As a result, the ad offered to sell a 1995 Jaguar XJ6 Vanden Plus at a price of $25,995 instead of roughly $37,000. The plaintiff, Donovan, read the ad and tried to purchase the car for the advertised price, which was much lower than the prices for this type of car offered at other local dealerships. The car dealer, however, refused to sell at the advertised price, explaining that there had been a mistake. Donovan didn't accept this and brought a lawsuit based on a breach of contract. Among others, the issue that was presented to the court was whether the car dealer could invoke the defense of unilateral mistake. The court held that there had been such a mistake. Consequently, the contract was not enforceable. In its opinion, the court considered the following four factors. First, whether the defendant had made a mistake regarding a basic assumption upon which the defendant made the contract. The court concluded that that was the case. The price was a basic assumption, and there was a material mistake given that the inadvertent 32% discount made the contract severely imbalanced and unfair. Second, whether the mistake had a material effect upon the agreed exchange of performances that was adverse to the defendant. Again, the answer was in the positive, since the defendant would have sold at a loss at the mistaken price. Third, whether the defendant should bear the risk of the mistake. The court said that it should not, because there had been no breach of duty towards the plaintiff and only simple negligence in making the mistake. Finally, as the fourth element, the court asked whether the effect of the mistake was such that enforcement of the contract would be unconscionable. The court found that this was the case and discount would amount to a windfall for the plaintiff that would be unconscionable. Hence, RRL Corporation was able to raise the defense of unilateral mistake and avoid the contract.